one misread gesture, one wrong assumption, and suddenly you're in court, facing $1 million lawsuit. Today on 10 on Tactics, we're exposing the razor-thin line between passive and active resistance, and how it can make or break your career in law enforcement. Hi, this is David for 10 on Tactics from tacticsandtrials.com. Please remember to subscribe to the channel and hit the like button. If you have any questions or comments, please leave them below. A cursory review of any police agency's use of force policy in California will almost always contain the phrases active resistance and passive resistance. These key phrases are used to provide guidance for an officer when engaged in a use of force encounter. Many courts in California have addressed the distinctions between active and passive resistance, particularly in the context of law enforcement's use of force. Understanding the distinction between active and passive resistance isn't just academic, it's essential. It directly influences the level of force deemed appropriate and lawful, objectively reasonable and necessary during encounters. Misjudging the level of resistance is one of the fastest ways to land in court. That misjudgment could mean disciplinary action, loss of certification, or a civil lawsuit with damages reaching 7 figures. This knowledge ensures compliance with legal standards, protects individual rights, and minimizes criminal and civil liability for both officers and their agencies. Accurate assessment aligns actions with legal standards and helps anticipate escalation risks, crucial in safeguarding everyone involved. Unfortunately, the reality of patrol often lacks the clarity that legal experts enjoy when reviewing body cam footage frame by frame from a secure courtroom. When it comes to passive resistance, courts define it as non-compliant behavior without physical aggression. Examples include individuals who ignore verbal commands but do not physically resist, such as sitting down, lying down, or going limp without engaging in threatening actions. Active resistance, by contrast, involves physical actions aimed at preventing officer control, pulling away, bracing, fleeing. These behaviors may justify higher levels of force, such as tasers or pepper spray, depending on the circumstances. California Penal Code 835 authorizes peace officers to use reasonable force to effect an arrest, prevent escape, or overcome resistance. That force must be necessary and proportionate to the threat posed by the subject. The California Commission on Peace Officer Standards and Training, POST, emphasizes training officers to recognize these distinctions. This is integrated into the post-basic course and further reinforced through department policies. Departments are urged to provide ongoing scenario-based training so officers remain sharp and legally sound in their assessments. In summary, a clear understanding of active versus passive resistance is essential for California police officers. It ensures lawful application of force, protects individual rights, reduces liability, and upholds the integrity of law enforcement agencies. POST defines active resistance as physically evasive movements to defeat an officer's attempt at control, including bracing, tensing, running away, or verbally or physically signaling an intention to avoid or prevent being taken into or retained in custody. This includes pulling away from the officer, tensing muscles to prevent handcuffing, fleeing the scene, hiding or concealing hands. These actions differ from passive resistance, which includes non-compliance without physical opposition, like going limp or ignoring lawful orders. California Penal Code 835A reiterates that force must be objectively reasonable, necessary, and proportional. POST expands this into 4 categories: passive resistance, non-compliance without physical action; active resistance, physical actions to prevent control; assaultive resistance, aggressive actions that may cause injury; life-threatening resistance, actions that pose a threat of death or serious injury. Let's examine how these categories play out in court. Bryan v. MacPherson. The Ninth Circuit held that using a taser on a non-threatening individual, despite his agitation, was excessive force. Bryan was yelling and slamming fists, but made no threatening move. The court ruled his behavior was passive resistance. Yount v. City of Sacramento. The California Supreme Court found that while Yount exhibited active resistance, kicking and spitting, the use of deadly force, shooting, was not justified. Even with resistance, proportionality remains key. Bell v. Williams, 2024. Vincent Bell, a detainee with a leg amputation, was forced to hop during a cell transfer without mobility assistance. He collapsed and was later carried in a humiliating manner. Despite any initial resistance, by the time force was applied, he had become compliant. the Ninth Circuit ruled in Bell's favor, citing violations of the ADA and the use of excessive force against passive resistance. Rosenbaum v. City of San Jose, 2024. Officers allowed a police dog to bite Rosenbaum for 20-plus seconds while he lay prone with arms outstretched. The court denied qualified immunity, stating a jury could find this to be excessive force against a compliant individual. Headwaters, Forest Defense versus Humboldt, 2002. Environmental protesters locked arms in peaceful protest. Officers applied pepper spray with Q-tips directly to their eyes. The court determined this was excessive force against passive resistance. Perhaps the most critical takeaway from these cases is how fast these encounters shift. Within seconds, someone who appeared passive can become a deadly threat or remain compliant while the officer crosses the legal line. For officers in California, knowing the difference isn't optional. It's the only thing standing between a lawful arrest and $1 million mistake. This is David for tacticsandtrials.com. See you next time for 10 on Tactics.